Welcome everybody. My name is Matthew Herder and it's my pleasure to welcome you here and introduce our speaker, the final speaker for our seminar series this year at the Health Justice Institute here at Dalhousie. DAL operates on the unceded territories of the Mi'kmaq, the Wolastoqey, and the Beskow-Domukati peoples. These sovereign nations hold inherent rights as the original peoples and keepers of these lands, and we each carry collective obligations under the Peace and Friendship Treaties. Section 35 of the Constitution Act 1982 recognizes and affirms Aboriginal and treaty rights in Canada. We also recognize that African Nova Scotians are a distinct people whose histories, legacies, and contributions have enriched that part of Mi'kmaq known as Nova Scotia for over 400 years. It's really a pleasure for me as a colleague, as a friend, as someone who greatly admires Sheila's work. She really doesn't need much of an introduction. She asked me not to really do one, to give more time for the presentation and discussion. But I just want to say on a personal note, and a note that I think extends to everyone here and beyond, Sheila is a rare scholar whose work is both expansive in terms of the material and issues she engages with, but so grounded at the same time in personal relationships in a deeply human way with people in the community experiencing marginalization in many forms. And I can think of no better person, even if it fails to play with her title for a bit, to think about this turn that we're really excited about taking, continuing, and expanding upon at the Health Justice Institute around really leaning into and making our work community-centered, community-led, in allyship with many community-based actors. And so it's really exciting to hear Sheila sort of expand on that vision here today, share some of her work, and talk about what this shift at the Health Justice Institute might look like in conversation with you. So Sheila.
Thank you. Thank you, Matt. Let's see. Oh, there we go. So really happy to and grateful to be able to speak with you today. So when I stepped in as Health Justice Institute Director in July, I inherited a question, which is this question. What does it mean to stand for health justice and work for health justice in these troubled times? Times of war, climate crisis, accelerating material inequality, the rise of authoritarianism, and with it, a retraction at the highest levels of power from even the facade of commitment to global health, climate justice, medical science, human rights. I ask this question not rhetorically or idly, but with purpose, as someone working here and now at this university, directing the Health Justice Institute, which spans faculties of law, health, medicine, and dentistry. What should we do to support health justice in these times? My remarks today offer a preliminary and partial response, reflecting my scholarly and advocacy focus on decarceration and deinstitutionalization, projects anchored in health justice or equitable access to the social determinants of health. My aim is to draw from those examples and take stock of related themes in my research, and to propose one small way that I and we at the Health Justice Institute might contribute in a way that seeks to honor and amplify community-embedded insights about health injustice and justice in a world of increasingly remote and abstract legal and health professionalism and knowledge production, a world, and I include in this the world of our students, increasingly starved for human connection and purpose. So I preface my remarks with acknowledgement of our locatedness in Mi'kmaq, honoring the Wabanaki traditions of stewardship and connection to and on these lands is fundamental to health justice amidst generations of colonialism, including colonialist university dealings. I'll start, here's the plan, with 2 case studies centering deinstitutionalization and decarceration, and intended to distill insights and questions on what it means to pursue community-engaged health justice in the here and now. Then I'll trace a path through my community-engaged research and service, a story of hope and of progressively failing better, as I say. I highlight a few examples I describe as efforts to amplify subjugated knowledge and connect that knowledge to the wider project of health justice. And I conclude by describing an initiative that Professor Herder and I and others at the HJI are launching, Community Health Justice Partnerships. What this is, what it might be, is something that I invite you to imagine with us as we explore new ways of connecting legal with health professionals, individual problems with social structural determinants, individualized with systemic advocacy, heart with mind, and the university with the wider community in the service of health justice. So let's start with what is health justice. The Health Justice Institute changed our name to Health Justice from Health Law Institute a few years ago to signal a deepened commitment to interdisciplinarity and to recognize that law has frequently been a source of injustice, corrosive to health, particularly for communities subordinated by colonial, racist, heteronormative, and ableist inequality. At the same time, our name change picks up on a scholarly and social movement trend reflected here on this slide, where health justice is defined as both a framework for health law and policy scholarship and a social movement. On this approach, as a research framework, health justice engages the role of law and policy in creating and potentially dismantling subordination in healthcare and public health. Here, the normative anchor is intersectional substantive equality, a concern to redress inequitable access to social determinants of health on grounds of race, indigeneity, gender and gender identity, and disability. That imperative may be traced to international law on the right to health and the social, economic, and cultural rights that underpin it, as well as anti-discrimination law. This same imperative of intersectional substantive equality drives the health justice movement, which seeks to overcome and remediate inequitable access to the social determinants of health. As defined, health justice is a big tent. It encompasses scholarly inquiry as well as social movement advocacy on, say, climate justice, indigenous justice, reproductive justice, justice in access to essential medicines, and more. Its strategies, both scholarly and movement-based, are similarly capacious. Health justice scholarship tends to be deeply interdisciplinary, connecting legal analysis to quantitative and qualitative empirical inquiry. Further, while it does not narrow to a single research method, it is closely aligned with action research, involving community-led design and pursuit of research questions, engaging live problems those communities seek to solve, drawing scholarly and movement aspirations together to support those directly affected by health inequalities to create and sustain the conditions of health and justice. My work in recent years has focused on one corner of health justice, namely how coercive control across both justice-based and care institutions interacts with inequitable access to the social determinants of health. I situate that work in light of social determinants research, for instance, affirming the bidirectional relationship of psychosocial disability with poverty, homelessness, and other forms of social exclusion. Further, I and others explore how disability institutionalization, segregating people in congregate spaces and depriving them of choice and control, is constituted by deprivation of the social determinants of health. For its part, criminal law incarceration is not only overrepresentative of people with disabilities, but also of people with disabling social characteristics, including poverty, homelessness, childhood trauma, and involvement in child welfare systems. Indigenous people and people of African descent are also, as you know, grossly overrepresented in prisons and jails. In short, the social determinants of disability, disability institutionalization, and criminal law incarceration overlap in significant ways. The common foundation of criminal law incarceration and disability institutionalization in lack of access to housing, income, and other social determinants of health may be more constructively stated as a thesis about the health and justice protective factors conducive to health justice, disability justice, race and indigenous justice. This further cashes out as a question, namely, how might we advance decarceration and deinstitutionalization by promoting equitable access to the social determinants of health, to adequate housing, food, income, the social bases of self-respect, in a manner reflective of intersectional substantive equality. So I offer a few touchstones from which I draw inspiration in answering that question before turning to my case studies. I start with the social movements and community-based organizations in our backyard that make it their business to pursue equitable access to the social determinants of health and resist health-harming institutionalization and incarceration every day. I'll come back to these grassroots players in the space of decarceration and deinstitutionalization as I go through, and I'm co-chair of one of them with Renford Ferrier, my co-chair. That's East Coast Prison Justice Society. Sonia's here, who is our amazing staff, answering our phone line. Not answering it right now, but relatedly, I draw inspiration from Andrea Ritchie's and others' elaboration of a Black feminist praxis of emergent transformative justice strategies in troubled times. Ritchie analogizes emergent strategies to coordinate organic microprocesses like mushrooms detoxifying soil after disasters, and argues that even small moves to animate justice at the level of our relations to ourselves and those immediately around us can have transformative effects over time. Emergent strategies stand in contrast to mass movements and hierarchical or linear strategies, embracing creativity, imagination, experimentation, also grace, kindness, and care to guide resistance to the violence and war endemic to white supremacist and colonialist capitalism. In a related vein, I'm inspired by an idea resurfacing in critical theory circles, that of prefiguring justice, described by Allegra MacLeod as the imagining and generating of alternative institutions and relations based on equity, mutual aid, and self-determination. Originating in 1960s anarcho-syndicalist critiques of statist Marxism, the idea is to act as if the revolution has already happened and shape one's legal and social relations in ways that reflect movement goals. Examples include local exchange trading systems and buy-nothing groups, bypassing money markets while fostering social connection through direct trade and mutual aid. Another example in our midst is African Nova Scotia's community land trusts. My case studies and the community health partnerships I will speak to aspire to this ethos of instilling values and norms resistant to oppressive social and institutional structures through, quote, local efforts to imagine and manifest just relations in the here and now. My last touchstone is abolition remedies, an idea advanced in legal scholarship in the last 7-10 years or so after being well seated in social and political theory. This encompasses first the idea of non-reformist reforms. Popularized by Black feminist prison abolitionist Miriam Kaba, this means resisting reformist reforms premised on what is possible within the existing order, wins that carry bigger losses, like a win on prison overcrowding resulting in new jails. Non-reformist reforms focus on what should be made possible to achieve deep social transformation, like reducing high rates of pretrial incarceration by promoting new ways of supporting freedom in community. Second, grounded preventative justice is a term Allegra MacLeod uses to describe redirecting resources from carceral institutions to the means of advancing and protecting just community membership, like free and voluntary community-based healthcare, education, and safe and affordable housing. Third is the need to link up macro-level strategies, say systemic legal remedies in the vein of the Disability Rights Coalition case about to be explored, with micro-strategies like individualized habeas corpus applications that creatively anticipate and protect against incursions on transformative systemic change. With that, I turn to my two case studies, which elaborate my earlier claim that decarceration and deinstitutionalization are both grounded in equitable access to the social determinants of health, while also advancing a further claim that Nova Scotia is a good spot for creative prefiguration of the worlds we want, perhaps in part because we're so darn small. I was engaged with both these happenings in a tangential, though intense way, alongside many others, as a law prof, co-chair of East Coast Prison Justice, facilitator of an intellectual disability action research collective, My Home, My Rights. However, my remarks are rooted mainly in published documents and commentary. So first is Nova Scotia's COVID-19 rapid decarceration. On the one side there, this describes a 5-week period at the start of the pandemic in March, April 2020, when the provincial jail population in Nova Scotia was reduced by nearly 50% in about 4 weeks, the highest proportion released in the country. And the second is the Disability Rights Coalition remedy, a June 2023 Human Rights Tribunal settlement order obliging Nova Scotia to remediate systemic discrimination within 5 years by closing all large disability institutions, including supported residences with more than 4 people, and introducing individualized disability support funding. This is an extraordinary deinstitutionalization order, complete with reporting requirements, benchmarks, external expert oversight, and more, putting Nova Scotia on the global map as a leading example of law and social movement coordination. So starting with the rapid decarceration, my colleague who's here, Adelina F. Tene, there's Adelina, writes a wonderful article in the Dow Law Journal in the middle there, 2021 article, that by July 2020, most countries, and says this in the article, that in July 2020, most countries had failed to adequately heed early calls of international human rights and health groups to protect prisoners against COVID-19, such that by that time, across 36 countries, over 100,000 incarcerated people had been infected and over 1,500 were dead. Recommendations from international organizations focused on decarceration and providing housing and health supports on the outside, as well as public health measures inside, with monitoring for infringement of residual liberties. This was easier said than done. Canada's federal prisons, administered by Correctional Services Canada, rejected calls to decarcerate, although the rate of infection was over 10 times higher than in the community and over 77 times higher among federally sentenced women, all of which had disproportionate effects on people with disabilities inside. Disproportionate effects were, of course, also felt in disability institutions, where residents experienced harsh isolation and sometimes elevated rates of COVID-19 infection and death. Returning to that March 2020 weekend when COVID came down, the concern arose here in Nova Scotia among prisoner justice advocates that those incarcerated in the provincial jails would be forgotten, despite what we knew about their disproportionate vulnerability to infection, given overcrowding and overrepresentation of pre-existing chronic disease. Beyond Professor Iftene's article, placing Nova Scotia's rapid decarceration in a wider context of national and global public health measures, this slide features 2 publications by Ash Avery, who at the time of COVID's inception was ED of a group supporting justice-involved women and non-binary folks, Coverdale Justice Society. She's now ED of Feed Nova Scotia. One of these is her Master of Arts thesis, and the other an article co-authored with former prisoner and social justice leader, present social justice leader, Sarah Tessier, both reflecting on work on the front lines of release planning and support during this period. Avery's thesis, Frameworks for Freedom, recounts an array of creative measures taken by community organizations, some in collaboration with government and some as improvised mutual aid. East Coast Prison Justice was part of a coalition of nonprofits, including Coverdale, EFRI Mainland, Wellness Within, eventually the North End Health Clinic, Direction 180, and more, jointly drafting communications, and in the first 3 weeks of the pandemic, meeting with top officials, including Deputy Ministers of Justice, Community Services, and Municipal Affairs, to promote expedited bail reviews, conditional release, accelerated health and income and housing supports, intersectoral bail support planning, and more. The unity of purpose was moving and tireless. That said, there were missteps. I and others found ourselves repeatedly describing, because it was effective, provincial prisons and prisoners as quote-unquote vectors of contagion, requiring release for the greater good. Among the most radical developments of the period was a homegrown expression of mutual aid whereby EFRI, Coverdale, and John Howard came together in unprecedented fashion to co-create supported housing for those rapidly exiting the jails. Avery describes the initiative, called JEC, as anchored in harm-reductive, trauma-informed, feminist and anti-oppressive theories and practices. Harm reduction supports were provided by North End clinic staff and formerly incarcerated peer mentors, including dedicated Indigenous, African Nova Scotian, and queer peer supports. Clients were assigned a caseworker for navigating longer-term housing and health needs. Halifax library staff were on site, renewing pre-existing relationships with those who previously had found shelter and community in the library. JEC quickly became a go-to for police, rather than the lockup or drunk tank. None of the over 40 people supported over the 5 months it ran breached their conditions of release. However, federal funding dried up after a few months, and government, specifically community services, took over placement and case management, absent harm reduction and other supports. Avery observes that while federal funding for nonprofit-supported housing later expanded, the harm reduction approach, which had protected against breaching and reincarceration, was not replicated. She adds that the province has since invested in technological over community-led, including Indigenous-led, bail supports. By the fall of 2021, the Nova Scotia jail population had crept back up to pre-2020 levels, and incarcerated people were subject to harsher conditions than ever, including prolonged lockdowns, seriously impairing physical and mental health. In sum, Nova Scotia's rapid COVID decarceration prefigured abolition in the style of grounded preventive justice, but all too fleetingly. Unlike the rapid deinstitutionalization story, my second decarceral case study, the Disability Rights Coalition case, features litigation as a key driver in coordination with gradually intensified social movement advocacy. That said, the lines blur a bit given the sustained social justice engagement of the lawyers leading this case on the right there. So poverty lawyer Vince Calderhead represented the individual and represents the individual complainants, although all but one have died. One of the original complainants was Beth McLean there, and also on this side are other social movement actors, so Disability Rights Coalition spokespeople, Vicky Levac and Lita Jarvis. So there's Vince. Back to the lawyers, Claire McNeil of Dow Legal Aid, representing the Disability Rights Coalition. Now it's Katrin McNeil, yes, is representing. Not to be forgotten is Dow Law's Diane Pache, who contributed to the launch of the complaint in 2014, including through co-design of the first iteration of the systemic remedy. The groundbreaking remedy I already described, requiring deinstitutionalization within 5 years, originated in a statutory human rights complaint brought by McLean and 2 others who had lived for over 10 years in a hospital ward reserved for people with concurrent psychiatric disorders and intellectual disability. Why over 10 years in a clangy, bangy, terrible, emergent psych ward? Because according to the province, there were no appropriate community spaces for them. The DRC joined to say the core problem was not individual, it was systemic. Many were similarly wasting away in high security institutions or on wait lists for appropriate residential supports and living in inappropriate spaces in community. The analytical core of the case was discrimination, lack of equitable access to social assistance. That is, in Nova Scotia, non-disabled people are formally entitled to social assistance without delay, should one meet income criteria. Yet if one is disabled and owed assistance through disability support, one was placed on decades-long wait lists or in a controlling institution. In 2021, the Nova Scotia Court of Appeal ruled that this was systemic discrimination. After the Supreme Court of Canada refused leave, the province and DRC entered into the historic settlement remedy that I've described, featuring timelines and benchmarks for closing Nova Scotia's disability institutions and adopting a rights-respecting system of individualized supports by 2028. To be clear, advocacy for deinstitutionalization had been pressed by Nova Scotia disability advocates and families since at least the 1980s. Report after report had exposed injustice, yet government did not budge. It was litigation that consolidated and activated a movement that at that point had no political clout, and it was litigation, plus litigation amplified social movement advocacy, that moved government to eventually accept the settlement. and recently to walk back from proposed disability support cuts. How the remedy is unfolding is a matter of public record, given the reporting requirements. However, there remains need for vigilance. In January, the DRC released comments on the province's progress at the halfway point. It recognized significant changes to the disability support system, yet called out a failure to meet benchmarks on release from the largest institutions and creation of community-based supports. On the side of hope and potential interconnection between deinstitutionalization and decarceration, Emma Halpern, ED of EFRI Mainland, shared recently that a year or two ago, after a session at DAL on the DRC remedy, she, i.e. EFRI, reached out to the Disability Support Program, and this led to a new supported housing initiative through which 8 women with complex mental health challenges, addictions, childhood trauma, and criminalization, who'd cycled for years between prisons, involuntary hospitalization, and homelessness, now live independently in their own apartments, with staff who provide care and community completely removed from the hospitals and criminal legal system. That, in our small world of Nova Scotia health justice, is earth-shaking. So what takeaways might these case studies offer? For me, there are at least 2. First, the transformative power of community-led justice strategies. The rapid COVID decarceration story, in particular, reminds of the importance of building relationships of trust over time among nonprofits, with marginalized constituencies, and with government, to support mobilization of services to the most marginalized in times of emergency and also at the best of times. Second, the transformative power of creative lawyering. There is in the law and society literature a well-developed critique that litigation sucks the radical potential from social movements. Yet a competing, increasingly robust literature focuses on creative, community-connected lawyering, designing and pursuing legal remedies with social movements in ways that stay attuned to the goals of system transformation. Benefits of such alliances include strengthened public narratives about movement goals and struggle, coalition building effects, and instilling rights consciousness and empowerment among those long treated as lacking agency. So just as Nova Scotia's COVID-19 rapid decarceration is exemplary of creative community organizing, facilitating equitable access to the social determinants of health, so the DRC case is exemplary of creative social movement lawyering, strengthening social movements by anchoring them in legal authority. Yet these examples also suggest the vulnerability of deep transformative change to the social, political, and economic structures that make prisons and disability institutions, as well as poverty and homelessness, seem necessary. Liat Ben-Moshe and others have shown that both deinstitutionalization and decarceration are chronically vulnerable to neoliberal imperatives of cost savings, retracting or reneging on community-based supports while playing up the need for coercive containment of the dangerous or incapable few. From this follows a few questions, namely, how can transformative reforms like these health and disability justice wins be sustained? More pointedly, from where I stand, how can universities promote health justice, a health justice teaching, research, and service ecology that respects and fosters the leadership of communities lacking equitable access to social power? More pointedly still, how can we at the Health Justice Institute contribute to such work, acknowledging that much is already being done through such critical vehicles as Dalhousie Legal Aid and Dal's social work, family medicine, and dental clinics? So here my remarks turn to method, taking stock of a strand in my scholarship that helps contextualize the vision of community health justice partnerships that I'll close with. And from there, or sometimes we, gradually surface justice insights, bringing the story into relationship with systemic analysis about how health and disability injustice is produced and sustained, and how the conditions of that injustice might be transformed. So the method might be described as an effort at narrative justice. Distinct but related is a project in some of my work of seeking to expose and unseat epistemic injustice a term some of you would be familiar with, it's in the literature. Epistemic, like around knowing, injustice. And this is the assertion of expert authority and institutional power to deny what individuals and communities know about their own lives. As a means of countering epistemic injustice, narrative method, or narrative justice, seeks to activate the power of individuals and communities to shape and control the stories through which their identities and capacities are constructed. Narrative justice includes, but is not reducible to, the powerful tradition of counter-stories in critical race, indigenous, and disability theory, a tradition harnessing the power of stories to surface embodied justice insights rooted in marginalized and resistant subject positions. Narrative justice might also include deep listening in clinical law, mindful engagement intended to disrupt tendencies of legal and other professionals to impose their narratives on those they serve, and also as a means for the professional to check in on their nervous system responses. Troubling narrative justice is the question of whether or how those who are not members of a given justice-seeking community might enter into narrative justice engagement without exploitation, extraction, or hurtful distortion of other stories. Who can tell or retell health justice stories in situations of asymmetrical power is a central question for social movement lawyers, just as it is for interdisciplinary health justice educators, students, and researchers. So with all that trouble in mind, let me turn to some stories from my career as a legal scholar, such as it is. A career of progressively failing better at critical, community-engaged scholarly praxis. I take this circuitous route on the way to introducing the HJI's Community Health Justice Partnerships, our plan for interdisciplinary, community-based education rooted in narrative justice and slow justice, in deep listening as both method and ethos, including listening across profound differences in identity, background, and communication styles, in the hope we might work together to connect individual problems to structural conditions and collective strategies. So again, my method, such as it is, in a thick strand of my scholarship has been to dig into an individual story, perhaps paradoxically, to redirect attention from the individual, viewed as the site or source of drama or crisis or disruption, to the social or institutional structures that precipitate or exacerbate crisis and coercive social responses thereto. I'll start with my earliest work on the Supreme Court of Canada's 2003 decision in Starson and Swayze. Read narrowly, Starson was about legal capacity to make decisions about psychiatric treatment. Starson's doctors had determined that his rejection of both the diagnosis they assigned him, schizoaffective disorder, and their proposed treatment reflected a lack of insight on Starson's part, an inability to appreciate he was ill. The Supreme Court overturned that based on a sympathetic reading of Starson's asserted preference for his untreated over his treated condition, and an unsympathetic reading of the doctor's testimony that Starson's preferences were symptoms, not reasons. At first, I was interested in Starson as a story about law's vindication of value pluralism. But over time, what interested me more was a more complicated story, pieced together through tribunal transcripts, court decisions, other documents, about how decision-making capacity is shaped in relationship and undermined by coercive systems. For instance, I brought out how Starson's first encounter with police and hospital staff had escalated rapidly to restraint and forcible injection, an all too common pattern, which in his case set in motion a lifetime of adversarial struggle. Further, I focused on passages in the Supreme Court judgment largely overlooked in the case law and commentary, emphasizing the duty to address environmental factors that impair decision-making, such as lack of information, emotional upset, or sedating medication. In this way, I suggested that the court, or more deeply Starson's story, the court decision, or more deeply Starson's story, be read through the lens of reasonable accommodation, urging a shift in focus in the law and legal capacity, from capacity as a function of a healthy or broken brain to capacity as a relational achievement grounded in respect and trust, critical social determinants of health and justice. So it took me a decade to get Starson out of my system and wake up to the fact that I'd been working on ideas sympathetic to and yet in utter isolation from the wider disability justice community, including disability rights advocates and organizations representing people with psychosocial and intellectual disabilities in the negotiation and drafting of the UN Convention on the Rights of Persons with Disabilities, or CRPD. It took local disability rights leader Stephen Esty to come around proposing joint public education sessions at Dal for me to wake up to the importance of this treaty, engaging the radical abolitionist aspirations of global disability advocates in resistance to guardianship, institutionalization, and involuntary treatment, and in favor of supported community inclusion. Yet, as I relate in a 2013 article, those radical aspirations at the CRPD negotiations precipitated sharp divides between grassroots disability justice movements and psychiatric and legal expertise. Divides centered on the CRPD's Article 12, engaging equality and legal capacity, and Article 14 on liberty, and on who decides the legitimacy of state laws authorizing guardianship, substitute decision-making, and psychiatric detention. That rift and attendant worries about delegitimization of international law forms an important backdrop to my and others' work on health and disability justice and underlines the importance of shared deliberation or connected up knowing. This image looks ahead to my failing better post-Starson through work with an interdisciplinary group to create and pilot service user-led, art and story-based, supported decision-making workshops, which we presented for staff and residents in Nova Scotia's remaining large and largest disability institutions. In some way, that was the culmination of my earlier work on legal capacity as a relational achievement. But returning to those expert subject divides, I was invited in 2016 to participate in a co-authoring project connecting lived expertise and experience of disability injustice to rights-based law and policy reform under the CRPD. For this, I was paired with Rusi Stanov, who a few years before had won a landmark European Court of Human Rights case against Bulgaria, establishing his 10-year institutionalization in a remote facility at the instigation of a guardian as an illegal deprivation of liberty and cruel and unusual treatment. Rusi and I met 3 times on this Irish-led project in Galway and remotely many other times. Working together was as challenging as it was energizing. The distances, geographic, economic, linguistic, were vast. Further, even after his legal victory, Rusi remained under a Kafkaesque guardianship while cycling through institutions. This became a major focus of our chapter. If this is what happens to a human rights hero, what good are human rights? Our collaboration, supported by Rusi's longtime lawyer and interpreter, Annetta Genova, who's pictured there, became an exploration in bridging those distances, including through art making, storytelling, and what I reflect on in our chapter as gifting, ways of recognizing and exchanging value outside dominant market norms. On this slide is a drawing Rusi made one afternoon amidst stories, absurd and sad and crazy, and air guitar and bouncing on the bed, and it depicts an image that Rusi said he had drawn repeatedly with a stick in the road as he walked to and from the institution every day, looking for a little day work or conversation and looking to get away from the drugging and torpor of that place, which I have a picture of. I went and visited later, and it really is a haunted horror place. I find the figures that he drew transfixingly ambiguous, locked in a position of domination, subordination, or maybe it's a dance. It's a little like our writing project. I am an emotional person. Maybe this is why I do this stuff. This next sentence is like that Rusi died, from so-called natural causes, hastened by years of abuse and social neglect, just before our chapter was finalized. The final form of the chapter centers Rusi's entries in a journal addressed to me and my responses, placing his experience in dialogue with human rights law and its limits. It was tragic that Rusi did not live to enjoy his authorship and our book launch party and so much more, the sustained freedom and reciprocity and love that he so hungered for. So my work on Starson was on Starson. My work with Rusi was in relationship, however imperfect and partial and complete. I had failed better. So this part gets fun. Co-authoring with Rusi motivated me to become more engaged with disability justice and deinstitutionalization at home. This led to more community-embedded advocacy, lending my legal analytical and research and listening capacities to movement goals. Eventually, I obtained Shirk Partnership Engage funding to co-launch with Inclusion Nova Scotia the action research collective My Home, My Rights, led by people with intellectual disabilities in paid researcher roles. The collective used creative methods to define and explore a research question that core members chose. How can we use human rights so that people with intellectual disabilities are included and respected in community? So core members made and found art to guide conversation on human rights and what they mean in members' lives. We advocated around themes that came up in those conversations, particularly closing institutions and creating inclusive communities. We made a multimedia art show and exhibited it at the Halifax Central and Alderney Gate libraries. That was so great. We made videos based on members' stories with scripts co-drafted and improvised by members. The videos are available on the DRC website and Inclusion Nova Scotia websites, and they've been licensed to NSCC to train disability support workers on human rights practice. We gave presentations to local nonprofits on what distinguishes support from control or denial of agency. Core members presented at international conferences, and believe me, finding the money for that, that's a whole talk in itself. I've got some people who helped with this here. It's great. In Ghent, Belgium, where we also exhibited the art show. At the UN in New York, where we co-hosted a side event on inclusive advocacy and human rights consciousness raising. And most recently in Dublin and York, UK, we co-hosted a workshop on using art to support peer monitoring of human rights in disability services, something I'll come back to, although I'm having to speed up. These are examples of the collective's photo portraiture, co-designed by members and photographer David Simmons, and juxtaposed in our art show with member statements to express how each is the author of their story about human rights at home and in the community. The most important project outcome is how each member has since asserted leadership at home and in the community. Simon Snyder and Connor Clory are now president and vice president of People First Halifax. Simon and Chantal Meister co-designed and led the arts-based supported decision-making curriculum I described and are sought-after speakers. Chantal just texted me last night to say she's speaking at White Point, getting $500 for that or something. Ise Esti was not only a youth delegate at the UN, and Ise speaks through letterboard and his own sign system. This is Ise here. He was a youth delegate at the UN and also lead plaintiff in a class action on institutionalization, which recently settled for $33 million. Melly Thompson and Jan Walters have asserted themselves as disability justice leaders in the organizations that support them. So there are other stories I'd like to tell of community-engaged co-creation and mobilization of knowledge and justice. Instead, I'll just point to the ecology of local organizations working every day to connect individuals to social determinants of health and justice, preventive of incarceration and institutionalization, the legal clinics and nonprofits doing anti-poverty work, prison justice work, work resisting and redressing colonial, racist, heteronormative, and ableist discrimination. A more pointed example of community-led justice advocacy, and thank you, Sonia, for posting this. Sonia's gone. She had to go answer the phones. Sorry. This as I turn to what the HJI might do, including to better support community action research. Here's a recent report by Randolph Riley, anticipated at last year's Black Justice Strategy panel for the seminar series at which he spoke. Randy's African Nova Scotian roots and experience of federal and provincial incarceration prior to the overturning of his conviction position him as an expert on systemic discrimination affecting persons of African descent. An expertise deepened and sharpened in this report, which presents and contextualizes FOIPOP data on disproportionate isolation of persons of African descent in Nova Scotia's jails. We just released this. You can find it on our website. So finally, I arrive at the vision for community health justice partnerships at Dell's Health Justice Institute, a response partial but hopeful to the question with which I began. which is how can we help support and sustain health justice in these times? How can we foster and ensure fidelity to social movement wins, like the rapid decarceration and disability deinstitutionalization examples I've described? And how can we do so in ways responsive to distinct communities' health justice priorities, linking individual injustice to systemic remedies, while also supporting students and advocates to sustain health justice work amidst so much suffering and violence, both fast and slow. So the Community Health Justice Partnership Initiative we're launching is rooted in an established model of health justice advocacy called Medical Legal Partnerships, or MLPs. Yale Cannon has spoken about this previously in the series, as did Tess Sheldon just a few weeks ago. This describes a deeply interdisciplinary way of advancing health justice by integrating lawyers onto healthcare teams to address what's called health-harming legal needs through individualized and systemic advocacy. Here, health-harming legal needs means barriers to accessing the social determinants of health, such as income, housing, or employment security. And I could go into the history, but I'm going to skip that right now. Love to talk about it if you want to talk about it in the questions. A growing body of research confirms the benefits of MLPs, including reduced emergency room visits and hospitalizations, increased access to social benefits, and enhanced disciplinary collaboration to promote these ends, all of which have produced cost savings to healthcare systems. Further, MLPs have contributed upstream population health benefits through systemic advocacy, for instance, changing policies and practices to reduce delays in accessing important social benefits. And there's lots of great literature out there. I'll skip these detailed slides on activities and impacts of MLPs, which I provide simply to show that there are detailed schematics on point. Basic components of the model include community consultation, education and empowerment, interprofessional, community co-led collaboration and research, and individualized and systemic advocacy. So some interesting slides coming, but I don't want to dwell on it now. Yale Cannon adds the important argument that medical legal partnerships should identify racism as a specific expression of social structural injustice rather than take a singular poverty orientation, or if not, we risk reinforcing race injustice. This requires education and advocacy surfacing and challenging systemic racism, and I would add systemic racism and ableism as these intersect with colonial injustice in health and related social systems. Cannon adds that MLPs should extend into criminal law settings where mass incarceration is itself a health-harming legal problem, producing related legal needs associated with specific remedies like habeas corpus, compassionate release, parole. And with that, I finally turn to the community health justice partnerships we're launching at the Health Justice Institute. So what we envision reflects our engagement with other health justice partnership initiatives like Yale Cannon's and Tess Sheldon's Windsor Law Mental Health Justice Partnership model, bringing law students into collaboration with the Empowerment Council at CAMH, as well as drawing on our own local connections and capacities. Like medical legal partnerships, the model we're building starts with the recognition that inequitable access to the social determinants of health leads to poor health outcomes. To that, we add the MLP commitment to interdisciplinary collaboration to redress those inequities. Finally, to Cannon's point, our nascent model seeks to recognize that carceral settings, including prisons and disability institutions, express and exacerbate health justice inequalities in ways that systematically and disproportionately do harm on grounds of race, indigeneity, as well as disability. Further, in advancing community health justice rather than medical legal partnerships, we recognize that medicine and law have themselves been barriers to health and disability justice. We aim to co-create and implement this model in collaboration, not only with health clinicians, but also with community justice workers in nonprofits and other embedded experts able to inform individualized and systemic advocacy. So here's the calendar description. The seed of the initiative is a practicum course starting this fall, and I'll add, and this is big news, so wake up now, you're starting to fall asleep, so am I. We're in the process of hiring a chair in community health justice partnerships who will help refine and lead the course and related initiatives. So here's the calendar description, which describes community health justice partnerships as community-centric initiatives bringing together healthcare professionals, community justice workers, lawyers, and students for cross-sectoral collaboration and problem solving to address health inequities arising from unequal access to the SDHs, right? Income, housing, employment, and related denial of rights and agency in health, justice, and community services. And it continues. This full year course, so we have a full year, all the time in the world to slow down and reflect and connect. We'll bring together law students and students from Dow's Faculty of Health for classroom-based learning and community service responsive to intersecting discrimination, which creates and perpetuates poverty, criminalization, and other health-harming injustices. It's social work that we have our eye on to start. Social work students, really excited about that. The practicum sites are envisioned as fourfold, with more to come, contingent on further conversations following the arrival of the chair. These include an Indigenous health justice site focused on Jordan's principal work. That would be work assisting Indigenous children and youths and families denied disability and other social supports. My colleague, Professor Naomi Metallic, and alumni David Taylor are well positioned to advise on such cases. Both were integral to the Caring Society litigation. Second, a disability health justice site at the Arts Forward Drop-In, run by or co-run by Prescott Group and Club Inclusion, where disability support and access thereto, including supported decision-making, may be of interest. Again, we'll make this up with the groups involved. A prison health justice site engaging East Coast Prison Justice, Path Legal, and EFRI clients affected by health, disability, and prison justice issues, from compassionate release needs to restraints and seclusion. And a family medicine health justice site where, for instance, assistance to newcomers seeking individual and family supports may anchor our engagement. To be clear, this will not be a full-service clinic. Community consultation and legal education will not require lawyer supervision or law firm infrastructure. But in contrast, individualized client relationship building and advocacy will be contingent on and supported through partnerships with law firms and legal aid clinics external to the HJI. The aim is to add value to those firms and to community organizations and to communities we engage through responsive public education, assistance with complex cases, potentially leveling up to test case litigation, and the community engaged interdisciplinary acculturation of legal and health professionals along the way, and investment in health justice futures. We further promoted the practicum as reflecting a commitment to narrative justice, supporting people with health-harming legal needs to tell their stories in the way that's right for them, including by offering more expansive or creative opportunities to do that than there's space for in a traditional legal service relationship. This is complemented by a commitment to slow justice, taking the time to listen and work collaboratively toward holistic, sustainable change. To this end, we'll work with partnered sites to identify a maximum number of clients per interdisciplinary student pair. Students will be paired up, law and social work, at these sites, and ensure that clients who enter into retainers with partnered law firms or clinics and undertake supervisory roles, that those clients will meet with students for a period appropriate to their needs, potentially weeks or months. So in short, we intend the practicum to center holistic learning, deep listening, including through narrative and arts-based engagement, aimed at connecting individual problems to systemic causes and solutions. And I'm going to leave questions around evaluation. I wasn't going to go into it, but we're really excited to engage the question of how we will measure success of this initiative in ways responsive to and inclusive of the expertise of those communities served. And I close with this gesture to what else may fall under the umbrella of community health justice partnerships at the Institute. Possibly one is an initiative I'm exploring with an international network of academics and self-advocates, which involves mobilizing disability support service users as arts-based consciousness raisers and monitors of respect for human rights in disability services. And that idea was something trialed in 2023 at a workshop where advocates celebrated the disability rights leadership of Stephen Esty, and it also builds on the work My Home, My Rights did with Inclusion Ireland this past spring, and I really am going to Stop now. Is it really? It's 5 after, right? That's not too bad. I'm not the worst. So I began by asking what we should do to advance health justice in these troubled times. My 2 case studies on radical decarceration and deinstitutionalization in Nova Scotia remind us that sustainable health justice demands a joined-up ecology, engaging grassroots organizations, lawyers, and allied social movement supporters. I argue there's a critical need for university-based actors to engage our tripartite responsibilities of teaching, research, and service to advance health justice, including but not limited to the projects of deinstitutionalization and decarceration. So the Community Health Justice Partnership vision that I shared is one way of activating our capacities to promote and sustain equitable access to the social determinants of health in a way that's responsive to community priorities. So really finishing, I hope to have convinced you through my reflections on progressively feeling better in the co-creation and mobilization of knowledge that there's a need for narrative justice, for slow justice, arts-based, other deep listening practices as we seek to do health justice. Not just identify health-harming needs, but prefigure that. I was going to say something, but I can't. So I had that ahem thing, the just relationships we want. That's what we're prefiguring. Sorry. Didn't want to leave you hanging. Yeah, questions? I do have a song. I could play it at the very end if no one has a question, but we need not go right to the song.
We have time. Questions?
I wasn't going to sing it. I'm honestly not going to sing the song because I actually love singing, but I'm not very good at it. Yeah. Please.
So some colleagues and I hosted a symposium of folks who work in community-based organizations in healthcare to talk about moral injury.
Oh, yeah.
Dr. Lisa Barrett, our beloved infectious disease doc, gave a keynote talking about how seeing the swing back after deinstitutionalization caused so much moral injury that herself, and this I can share because it was a public talk,
Sure.
And many healthcare workers suffered serious life-changing occupational mental health injury. As a result of seeing the possibility of justice and the possibility of being taken away.
Yeah.
But I'm also thinking that the possibility of greater justice within those systems would also add to positive mental health and well-being of workers in community-based organizations and healthcare workers.
Yeah.
So I'm wondering if there's any plan to not just evaluate the program, but also to evaluate the benefits added to small CBOs that might actually be able to do more work on the front line and to reduce structural violence and the impacts of austerity on the organization.
Yeah. I'm going to go back to that evaluation slide because I went over it really fast. And this is a paper which is actually really interesting to me, and I need to spend more time with it. But it opens up this question: how should we measure? Because measuring these things is really hard. These partnerships have been around for decades, and they've been measured all kinds of ways. But sometimes the measure is not a great measure. It's not clear there's a causal effect. It's not clear they've sort of isolated the thing they're measuring properly. But it's also not clear that they're measuring what really matters, especially to, as you say, the communities and organizations most affected. And so this piece is exactly about that, somehow measuring the extent to which this kind of systemic moving from the individual to the structure work shifts power toward the impacted communities. And in order to sort of measure that, they go into it a bit. I think you'd have to have a process where you're co-designing, even the questions you're going to ask. I'd love the idea of this being a big action research piece from the ground up, so that those participating are thinking about how to measure it, thinking as they even go of what questions need to be asked. But just to go back to your earlier piece on moral injury, I'm really glad you centered that. I've used this language deep listening and stuff because I hope that I'm just as a person okay at that. I'm sometimes really bad. I'm actually a terrible interrupter. I keep trying not to, but I have an idea, I want to say my thing. I feel like I need the deep training of deep listening. I'm not the one who does that clinical training. At our Dow Legal Aid, they do a session in deep listening. Neha Acharya here is working on mindful, holistic teaching and lawyer practice, and I think in our ADR she addresses that. Anyway, I think it's a really interesting piece, and I'm holding great hopes that the chair that we're bringing in is, whoever they are going to center that in this year-long process with a very small group. It's 8 law and 8 starting social work working together and thinking about how do we slow down and listen, not just to the person, but my understanding of deep listening and some of these techniques is that it's at least intended to help you be aware of your own emotional response and try and find ways to put that in a place that allow you to keep doing the work, because burnout is so real, and I'm glad you mentioned that. And Lisa Barrett was so incredible and integral to those early days when I met. Is Lisa right here? Oh my God, you are there! You were. Look at you! Like you're such a rock star. I don't know. I think Lisa Barrett was sort of talking to absolutely everybody and was sort of inside and out, but certainly lent her expertise and insights to us, even just like on the side when we were trying to sort of figure out what was happening. So that is part of what I mean by our community being a place that, yes, you can feel the great weight and harm, but I'm so elevated by how people put their backs into building and keeping those relationships. It's staggeringly beautiful to me, and I think it can be sustained. So I don't know how to answer apart from that. That's great questions, yeah. Anything else? Hi.
When you're thinking about like partnerships and non-reformist reforms, can you comment a little bit on like reconciling an abolitionist sort of philosophy with having to partner with, say, like the prisons or the correctional authorities in order to do this work or to do research?
Yeah, I think that's really interesting. There was one point in there where I was saying that, in order to create this ecology, there's got to be all this relationship building, and I included government in there. And I thought, should I keep that in? Should I take that out? But just the brute fact of it, when I think back to what we learned from that time on, say, the COVID rapid, it was essential to have those lines of communication. They were changing policies on the fly and doing work. I mean, and in the justice sector, provincial court judge sitting over the weekend, that first weekend out to do bail reviews, there were many people with power who did things that were absolutely essential. So it's true there's a whole, not just literature, but a close study of how movements have risen and fallen. And part of it is about this kind of capture, like government captures the wave, and then it's kind of the story in part of the one I told. But I don't think we can just isolate. And so East Coast, right, works with corrections. We spent a long time to just sort of build this relationship where we could have a phone line from inside the provincial jails. And that partly involved, I think, establishing this common background understanding, even if we're adversarial, at some level we're all on the same page about something. And in COVID it was clear, it was public health. Like, Karen Hudson, who was Deputy Minister of Justice at the time, met with some of us. It was Easter weekend. It was a Saturday on the phone. There were a few people meeting, and Deputy Minister of Justice, Community Services, and Municipal Affairs was there, and she said, this is a time, I know it sounds like a cliche, but at the time I just wanted to write, this is a time we all have to row together. She was Deputy Minister of Justice and made things happen. So I guess I'm just saying, I'm not going to throw anybody out, but you've got to always work with caution, I think, and care about whether your values are still aligning. Yeah. Yeah, it's a good question, though. Anything else?
Thank you, first of all. It's just such a privilege to see the arc of this work and how it's all building towards this initiative in many ways. I just wanted to invite you to say more about epistemic injustice and the risks of it through this particular model, because what I heard you talking about a little bit is the guardrail is this process of narrative justice or slow justice and spending time. But are there any other ways that you envision through the course or other related initiatives that the people, the students, for instance, who will have expertise, right?
Right.
And they have to seed that to the actors that they're engaging with. So how do they guard against, reinforcing the fact that they're the experts and so on?
Okay, a couple responses. It's a great question. It's so important, and it reminds me of something like a hope for this practicum, which I didn't mention, but we've talked about it a little bit and sort of said, maybe we're going to hold off. We're not going to do it right at the beginning, but later we're going to try for this, which is to reserve a couple seats for community members. And so that might be community justice workers, might be people affected, but have a couple seats in the course for community members so that we're mixing that up. It was just hard bureaucratically to do that right away, but I love that, like I'm so committed to, and don't want to forget because you get all sort of bureaucratically encumbered. The other thing is, I think of my co-chair with East Coast, Renford Ferrier, who some people here probably have met because he's come in and talked in the prison law class and stuff. Renford, my God, like, he's so charismatic and so full of deep knowledge that people are just intimidated by him. Like, they love him, but they're intimidated because he knows so much. And I think being confronted with people who have that deep knowledge is the best way of undercutting any kind of like, let me tell you about the law. And that happens every time when we take the students into the, Adelina and I have done this, come into the provincial jails. And it's this idea that the students are going to be telling people, but we're always really careful to say, it's never going to be like you lecturing about rights in jail. Like, they have all topics and people go around the tables and it's always really fun. But what happens is, you know, the students sort of say, pop, pop, pop. And then the people are like, that's not how it works. It's like law in the books versus law in the streets. And it happens so actively and naturally. And the students come away just realizing that they've got to ask questions. Like, they really have to figure out what's going on. It's very disorienting in a beautiful way. And I assume that we want to create something like that here. Yeah. 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 Ah, Lisa.
I feel like, you know, like the Oscars, I'm at the Oscars with all of you folks here.
You're like an Oscar winner hiding in the back, all like.
Folks have done such amazing work, and I'm very appreciative of the talk and these pieces of work and bringing it together. And can't tell you how excited I am to hear about this practical thing. That's so nifty.
Yeah, me too.
I just came from another venue in Vancouver a couple of weeks ago where we had 30 people sitting around to talk about the 2% of the world that don't get any societal presence, including a lot of the folks that you were talking about today. And we came to a really long conversation about the weaponization of the term public safety.
Oh, yeah. Yeah.
So I'm interested in how you think that discussion or that narrative that's in the world, really, not just, you know, Nova Scotia, Canada, how that narrative might be something that is useful or not, and might that be something that comes into this practicum kind of conversation?
Yeah.
Politicization and weaponization of that term.
Yeah. There's so much to sort of, I mean, only to scratch the surface in this idea of narrative justice, but there's such danger to the way that stories and fixed, you know, ideas and concepts can be mobilized for the most sort of disastrous purposes. And right now we're in a context, as you folks know, where an orientation to even people who work in public health are asking themselves, how can I rebrand what I do to public safety so I can get grant funding? It's as simple as that. And people are actively doing this, like in droves. And so this question of how we understand public safety becomes very, like, pragmatically important. But it's also important from that bigger sort of social movement question of how you shift people's hearts in a way. Like, people's hearts are full of fear. So public safety is about, I'm scared. Like, and public health is more like this capacious, let's do something to all work together. And I know it sounds really simplistic, but I feel like some of that beautiful work, even that L. Jones led right around defunding the police, it's concrete. It's like, here's what we can do to build up actual public safety in ways that's responsive to the priorities to communities. Like, what does safety mean to you? What is a good life to you? Is it sort of living behind a little, like, all the locks and chains? Or is it something like creating good relationships with your neighbors? And we're in the camp here of the creating good relationships with your neighbor, curiosity about people, just reanimating that sense of curiosity, excitement, beautiful. Some of that stuff I think can be done through storytelling. Like, you know, people sort of there's experts in this stuff called social stories. We have someone on our board with these, like, I think there are some strategic ways to do that, but some of it is just, I guess, speaking back to you. What do you think? What do you think about that coming out of that conversation? What did you learn about that? I don't know.
We've got a lot to learn.
Got a lot to learn. Sorry, you know what I'm going to do? because I think this is a good segue. This is the craziest thing I've ever done, which you're going to love. So I wanted to end this with this song, because it's such a crazy way to end. But it's like, you know, the end of I'm closing out the Health Justice Seminar Series for 2026. But, you know, I partly just wanted to say, no more business as usual. Let's do something a little bit different. So this is Tona Mills. You can learn more about her on the East Coast Prison Justice website's Modest Memorial page, marking her recent death from cancer. She died too young, so much of her life was spent incarcerated, 10 years in federal prison, 6 of those in segregation, and another 13 in the forensic mental health system. Tona's name headlines a bill that Senator Kim Pate is trying to pass in the upper chamber right now, which among other things would require CSC to move people with serious mental health conditions from prison to hospital or community settings, even better. And she was my friend. So I first met Tona in 1997, although I didn't know it, when I told her story in a law school essay on violations of the charter rights of a set of so-called high-risk, high-needs, federally sentenced women placed in prolonged 4-point restraints at Nova Institution and then isolated in Spring Hill Prison for Men. And then I met Tona for real 20 years later. I was introduced to her by Kim Pate in 2019. We became friends. In the fall, this past fall, East Coast Prison Justice got a grant to bring Tona together with musician Simone Schmidt, who is my new favorite person in the world, to translate Tona's poetry and other writing into a song cycle. So as Tona lay dying, this is a few weeks ago, about 3, Simone played this piece. I'm going to play for you. I'll only play you like a minute and a half. I promise it's not like a 10-minute song. Played this piece for Tona. It's one Simone had written a few years ago, and Tona said she liked it. And it's called Leaning Hard on My Peripheral Vision. It sums up, I get all teary, but I'm going to make it. It sums up what I would like to express about deep listening, community engagement, affirming dignity where it's been violated, and affirming knowledge which has been denied, and cultivating attentiveness not only to what's right in front of us, but to who's at the margins on the way to health justice. And if this doesn't play, it's going to be like the most embarrassing time in my whole life. Hold on. There we go.
Peripheral vision, crawling on the edges of my mind, fading through the dregs of this condition. I can't abide, I got you on my side. The sun with 2 tongues, he is come. He is not leaving. You know we must face this eye to eye. Will that all move on?
That's Simone Schmidt, otherwise known as Fiverr, who's an incredibly talented person. So thanks, guys. That's it for us. Yep, bye.